Our next speaker is Lisa Goetz Gonzalez, and she's a disability attorney from Weston. And Lisa's coming up now. And after Lisa speaks, we'll have Q&A for both of them.
Hi. Good afternoon. Thank you for inviting me again to the MS Symposium. Stuart, you've done a great job. Thank you. This cause is true to my heart, so very happy to do this. I'm going to be talking about Social Security disability and how to build a case if anybody is applying for disability or getting reviewed. I'll be happy to answer any questions afterwards. Let's see. There are two main programs for Social Security disability. There's Title II, which is known as Disability Insurance Benefits, and there's Title XVI, which is known as Supplemental Security Income. Both programs differ quite drastically in terms of financially what you need to be able to qualify for one program or another. But in terms of what you have to prove to be disabled, those things are the same. Just to get an idea of the audience, how many people are currently on disability? Okay, and how many people are applying or in the process of appealing a Social Security disability claim? Okay, and how many people have been receiving benefits and have either been working or have received reviews from the Social Security Administration to see whether or not they should be continuing benefits? Okay, so I'm going to touch briefly on that because they are doing reviews. But for Social Security disability, you have financial requirements that are required for Title II benefits. If you've worked and paid money into the system, you would be applying for Title II benefits. If you have not worked, you would be applying for Title XVI benefits. Title XVI benefits has the added burden of showing financial difficulties, stresses. You have to meet the poverty line. Sometimes you may have worked, paid money into the system, have enough quarters of coverage, but the earnings that you made were not enough to bring you on a monthly income above the poverty line. So in those cases, they're called SSDC. They're concurrent cases, but basically they touch on both cases. Disability insurance benefits and supplemental security. Normally people just say SSDI, but they are a term of art, and when you apply at your local office, they will file for the application that you would qualify for. The Social Security disability definition. The disability definition is written in stone. It was established by Congress. It is when you are unable to work and perform substantial gainful work activity for a period of 12 months or more. It also can be if you have been unable to work and not perform substantial gainful work activity due to a medical impairment that will result in death. So if your condition is severe enough, it would be considered an emergency situation and they try to push it forward. But either way, you have to meet the criteria of being unable to work because of a medical impairment, and it's likely to maintain and continue 12 months or more continuously. There's a step 5 process, which is a simple evaluation, but every step is not as simple as it seems, but I'm going to touch on it very quickly. I do not have it on the slideshow. I do mention it though. One is step 1, are you engaging in substantial gainful work activity? If you are working and you apply for Social Security disability and it's considered to be substantial gainful work activity, you are denied benefits. If you are not working and you apply for Social Security disability, you go to step 2. Step 2 determines whether or not your condition is severe. Severe is a term of art, and as far as I'm concerned, any condition that has brought you to the Social Security office to apply, in your estimate, is severe. So if it's severe, we go to step 3. If Social Security finds that your condition is not severe, you get denied. At step 3, they try to figure out whether or not your disability meets or equals a particular listing of impairment. MS has several listings, and I'm going to go forward for the second part, talks about the criteria of impairments. So MS has several different criteria, but for that you need a lot of medical records, a lot of objective medical tests, be that MRIs, CT scans, blood tests, medical records, documentation of all the non-exertional impairments, which would be fatigue, tiredness. So they're going to see whether or not you qualify for these listings that Congress has brought out to mean you are disabled. If you meet or equal the criteria of disability under Social Security guidelines, you are allowed benefits and your case should be won. This is normally done at lower levels, at the initial level or at a reconsideration level. However, most cases go before an administrative law judge or above, and in that case, it was because step 3 was not met, and they did not find that your condition, even though diagnosed with MS, would meet or equal the criteria. If it is found to not meet or equal the criteria, Social Security must go to step 4. At step 4, the question is whether or not you have a residual functional capacity to perform your prior work. If you could perform the work you used to perform, Social Security must deny your claim. If you are unable to perform the work you used to perform, Social Security will then determine whether or not at step 5 you're able to perform any other job in the national economy. That's where most of the cases are heard and won at the administrative law judge level. So Social Security has these step 5, it's called a step 5 sequential evaluation. You can find it online, you can ask me about it. Feel free to email me with any questions, I'll give you my email. But really those 5 considerations are established by Congress, and those don't change. So I'm going to go back to slide 3, which is how, I think this is slide 3. I'm sorry, slide 2? Slide 3. Okay, so disability and the definition is an inability to work on a substantial gainful work activity due to a medical impairment. And then this is a blurb about the step 5s, but the step 5s were a little more detailed when I explained it. Are you able to do your past relevant work? Past relevant work is defined as any work you did 15 years prior to the date you last worked. 15 years prior to the date you last worked, not the date you get diagnosed, not the date you go to a hearing, but the date you actually last were able to work, and then they go for the last 15 years and consider all that to be part of the term of art, which is called past relevant work. Then the question is, if you're not able to go back to the past relevant work, which was step 4, at step 5, would you be unable to transfer or adjust to any work in the national, regional, or local economy? And all of them are fair game. So if you were to want to say, I'm not able to drive to work, or that job is in California or in Memphis and I can't leave, That's not a consideration. Social Security is a federal program. So if it's available in the national, regional, or local economy, an ALJ, an administrative law judge, can find that you are able to work and can deny your case. And then again, the disability has to be expected to last for 1 year or result in death. This is the proper preparation for a case, and I think all of the doctors that spoke earlier are touching on exactly what you need. More than anything is you need a doctor that's going to be on your side. It's part of patients' rights. 2 years ago when I spoke at your conference, I talked about patients' rights. I believe it's in the website. It's very detailed about the relationship you have with your doctor and what you need your doctor to be able to corroborate and write in their reports. So as an attorney or representative, because you don't need to be an attorney to go into Social Security and represent a person, you want to make sure that the case is properly prepared. You want to make sure that your medical records are up to date and concise. You want to make sure that all of your complaints are properly documented. So even if you have a day that you feel well and you go to a doctor and you say, I'm having a good day, that's great, but that's what the judge is going to read. And they're going to say, oh, you're having a good day. You've been stabilized, and in good days, what do you do? So it's important when you see your doctors to explain, a good day for me means I can get out of bed. I can return phone calls. I can have a conversation and not be in bed. I can do what normal and able-populated people do, able-bodied people. I can actually take a shower and maybe go out and socialize a little bit. Document exactly what it means, because it doesn't necessarily mean that because you had a good day, you're able to get ready, go to work, schedule the time that you're going to be in and perform work, which is considered 40 hours a week on a sustained basis. Your impairments are only supported by your testimony when you get to the appeals, to the judge's level. So you go up to a judge, and it is your opportunity to talk to a judge and say, my medical records weren't enough. So now I'm here to talk about and explain and support all of these medical records. So having a nice relationship with your doctor, getting the tests that you need, your MRIs, your TC scans, your bloods, all of those get evaluated. All of those are invaluable. One of the doctors, I think it was Dr. Steingo, who said, it's important that you take your medication. It's also important that you record when a medication is changed. So you may be able to be on the same medication, but if your dosage was increased by milligrams or by frequency, that's very important, because that shows that your condition is not stable. There have been changes, and these subtle changes are then brought up at the hearing level. Very, very important. The 5-step sequential process, which we talked about, all of this interplays. So when you see that wheel, it's really the proper theory of the case. As an attorney, I particularly don't go in and say, my client meets the listing of impairment, they have MS, we have these records to support. Because first of all, if it had been that clear cut, you would have been awarded benefits at a lower level. If we're in front of a judge, it's because it's a credibility issue. And now I feel that you need to come and corroborate these evidences, these medical records, and you need to testify as to your activity of daily living, how you spend your day, how you wake up, how you don't sleep, how many fevers you have, how much depression you may have or anxiety because of your condition, what doctors you're seeing for the medical that's mental as opposed to just for the physical part. And we put it all together into a proper theory of the case. and we weave it, and it's not as simple as, I think, and I've been very successful arguing, I don't believe it's as simple as saying, this is a diagnosis, this is a test, they qualify. We put everything together in a theory. So one of the most useful tools that may not be consistent, because Social Security is a lengthy process, it's a many times humiliating process. One of the main things that I say is keep a journal, because it's an administrative court proceeding. It is automatically included into evidence. The evidence laws of circuit court, federal court, don't necessarily apply in these administrative proceedings. They're meant to try to really bring out how that individual is on a daily basis and why this person really feels that they're not able to perform a 40-hour work week consistently. Journals are a great way to do that, because you submit them into evidence. They can have a year and a half of entries, whether it's every day, every month, and it gives a nice system of how this person is living. And outlining the preparation for the hearing. Some of the administrative law judges require briefs. Some of attorneys are very used to writing a brief so that the judge knows what we're going to be arguing, and there are no surprises, whether there's work in the file or anything that we need to clean up. Opening statements, some judges require them, some don't. Either way, whoever is representing you at that table where you're all applying, it's very important to have a good theory of a case, good opening statement, solid medical records, and a brief to support all of that together. I've taken a copy of a screen right now, Social Security, at the hearing level, not at the lower levels. So you have your initial level, you have your reconsideration level, and then if you're denied there, you request a hearing in front of an administrative law judge. If you are denied at the hearing level, this is as a sidebar, then you have the Appeals Council, which is in Virginia, and then after that you have federal court. So almost every attorney can go to the Appeals Council. Not every attorney goes all the way to federal court, and representatives that are not attorneys will be very happy to represent you at a hearing level. But then if you get denied, you want to make sure before you have any kind of representation that they're able to take you all the way if you need to. That would be my advice. But here's a flash picture of what they have electronically. Once you file your request for hearing, it takes about 30 to 60 days, where they're supposed to put all your documentation from your lower levels up to an electronic file. This electronic file you have access to as a representative or an attorney. I don't believe clients on their own have access to it because you have to apply and go through, for privacy purposes, you have to make sure that they know who you are, and it's a little bit detailed. But once you have this up, you're able to pull up any case that's at the request for hearing level. All of your medical earnings, all of your medical records are there. All of your earnings records are there. All the jurisdictional requirements are broken up, and that's a fancy word for saying where you filed for benefits, have you moved, what office takes your case. All the non-disability issues are there, and those are all the plethora of paperwork that you receive with how do you feel, have you improved, what do you do, where do you live, who does the grocery shopping. All that appears in these records. So when you complete those forms, you better believe that they're going to come back to Hatch at the hearing level. And I have 2 minutes left. So non-disability areas, disability areas, they're all broken down. That's where you submit your brief, your argument of the case. And that gives you a good indication of what you look on. You click on the particular things and your whole entire file shows up. It is real time. Once it's sent in, Social Security judges are looking at exactly the same thing you are looking at. Okay, this is my last slide, and this talks about the several levels I just mentioned: the initial, reconsideration, your request for hearing. If you lose at your request for hearing, your appeals counsel, then you have to file, and you have a right to file at the United States District Court in Florida. It's the Southern District. The criteria for evaluation using MS is listings, and this is where you have the 11.04, the 11.03C, and then you can do with motor functionings. You can also go into visual impairments. You can also go into organic, which is what they were talking about with cognitive. However, it's important to know this list is not all inclusive. This list is only really talking about putting it all together now. You have visual, you have motor, you have mental, put it all together in your brief. So we're available for any questions. And my email, if anybody does not get to ask questions, is Lisa, Lisa, @gglaw.info. Thank you.
Well, thank you, Lisa. I forgot to give plaques to both Rick and, well, I could give it to Lisa now too. So we want to give them their appreciation plaques. Thank you to both of you, Rick and Lisa. Thank you. Thank you. Thank you. And before we get into Q&A, I just got some good news. Dr. Jack Burks is going to wait till after the program. For anybody that's got those questions to do with neurology, after the raffle, he will come up here and he will take your questions for those in the audience. If we cannot do this live, but those in the audience that you want to come over and you have questions for him, he will be here to answer your questions. Great? Good. Now, who's got questions for these guys? There we go. Okay, wait. I'm only here right now by myself. Oops, I'm in the spotlight too.
Hi. My question's for Lisa. I just wanted to know, I currently work full-time, and just wanted, oh God, now I can't remember what my question. It's a relevant period is for 15 years after you stop working, that they look back for how much you make and how much you would get for disability? Or is that not?
Okay, so the relevant time period for how much you make, when you see that slide that shows your earnings record, is this better? The question was, what is the relevant time period that they look for the time period of the work you did and the amount of money you made? So the amount of money that you made is over a lifetime. The amount of work that you performed is 15 years prior to the date you became disabled. The date you became disabled is not necessarily the date you apply or the date you were diagnosed. It really correlates to the date you last worked. So the last time that you worked full-time, earning 40 hours a week, that's for Title II, which is one of the type of cases. For Title 16, which is when you haven't worked and put enough to bring you above the poverty line, then they still consider work activity, but the date that they consider your onset date is always your application date, regardless of when you worked. Does that answer your question?
Okay, Marie's got a question on the other side.
This is for Dr. Harris. Is neuropsych evaluation typically covered by Medicare?
Yes, it is. It is a standard covered charge under Medicare. Absolutely. Yeah. I'm sorry?
I lost it. Sorry. The other question.
We can evaluate that. and Medicare will pay for it. And then we can turn it over to Lisa and we can get you disability.
Do you have to have a referral from your neurologist?
No, you really don't. Psychologists under Medicare, if they're a participating provider, are independent practitioners, so that we would actually do what we call a diagnostic interview and determine the medical necessity of a neuropsychological evaluation, and it would be covered under Medicare. There's no referral necessary unless you have a Medicare HMO product. If you're strictly Medicare, you're good to go.
And Lisa, this is for you. You mentioned at the beginning that you would try and talk about Social Security reviews, and we didn't get that far. Can you
Yes.
speak to that?
Yes, I didn't get that far, and I apologize. Thank you for bringing that up because I didn't really think anybody was being reviewed. But there is there's a big movement right now to review candidates, whether or not they're on disability for 5 years or 10 years. It used to be that they were really reviewing people over age 58. Now I'm seeing people age 62 be reviewed. It's starting mostly, I believe it's in Tennessee, but we're seeing it in Florida also. Recently, I had 3 people that were being reviewed. It normally goes like this. A review goes with Social Security sending you a letter. Please send us all the updated medical records, the treatment forms, so that we can request these records and sign releases. Always cooperate, never say no. If you're not in treatment, that's the biggest problem. So I strongly urge everybody to continue treatment. Treatment can even be, for my purposes, twice a year. But you want to make sure that you continue. And what you have to show to be able to continue getting your benefits is that your condition has not improved. However, that does not mean, by definition, you will be discontinued benefits. One of the flags that I would urge everybody to remember, if you get reviewed, if you get reviewed and you get discontinued your benefits, Social Security then requests your records and determines that you have improved and you are no longer disabled. You only have 10 days from that letter to appeal and continue receiving your payment. Continue receiving your monthly. There's a double-edged sword with that. If you continue receiving your monthly benefits while the review process is ongoing, okay, and you lose your case, you will be charged with an overpayment, another trapdoor. So that's on a case by case, and I would be happy to discuss it, but that is an issue. And one of the big flags that trigger review is when you do not have medical treatment and they send you this routine letter, they will flag you, or when you have any earnings under your Social Security case, or if you're an SSI recipient only and you qualify as financially needy. And we do have many, many people where they win a little bit of money on the lottery and they send their Social Security number in and they collect money that will trigger them out of the program and ineligible. Okay.
Question over here.
A quick question. I had a psych evaluation about 10 years ago, and I had one about 3 or 4 years ago. How often should that be updated, especially for disability reasons?
Well, for disability reasons, they really don't care about any day prior to the time that they're deciding to review you. So if you had an eval 3 years ago, fine. If they review you today, you better get another eval immediately. That would be my suggestion, because you're just starting to build, and the trigger is not that you've gotten worse. The trigger is that you're the same and you have not gotten better.
I have a question over here.
Sorry, I couldn't hear you. Yes, sure, absolutely. As long as I need to stay, I will. Okay? Somebody? Yes.
Yeah, I was wondering if I have a partial military disability, can I get a Social Security disability as well?
Are you currently receiving both?
No, I'm getting a partial military disability. I was just wondering, can I also get a Social Security disability?
Yes, the requirements would be different. Long or short-term disability is a private contractual agreement that you have between your previous employer or your insurance company. It used to be that you could double dip. It used to be if your long-term disability policy was from many, many, many years ago, there was no offset. Today, they may decide, I have to read each policy independently to see whether or not there's an offset. The benefit of it is oftentimes the long-term disability is very happy because they collect a certain percentage of your retirement to pay you back. You pay them back, your future may or may not be untouched, and the Medicare that you get, or the Medicaid, but in this case it would probably be Medicare, is unaffected by your long or short term.
This is for Dr. Harris. Have you ever had a patient that had lost the ability to cry?
Have I ever had a patient lost the ability to cry? Yes, absolutely. One of the symptoms of some cognitive deficits are an inability to express our emotions. Also with some of the psychiatric disorders, such as depression. It's not uncommon to have a flattening of a mood, and it is a symptom, could be a symptom of depression and inability to cry, absolutely. And therefore, that's why it's important to have an accurate assessment to understand what that's about. Is it a psychological issue? Is it a cognitive issue? There are some side effects with medications too that blunt our affect, where a range of experience of emotions are flattened. So it's important to have a pretty comprehensive assessment to assess that.
I have a question here.
Talk into the microphone, please.
Can you hear me now? Yeah. Yes, so I have a question for each. The first is on the Social Security and of process understanding. And I know we're supposed to not ask individualized personal questions, but I guess we can't help it. So when I had applied for my Social Security, went through the process, and they did the physical evaluation, all the gazillion questions over the phone and all the forms and et cetera, et cetera. And I always followed up, and then I found out that they were done and they had made a decision, and I called to find out, and they said yes, they had made a decision. However, it had gone for audit. And then, and so they wouldn't know anything until the audit was done, and I would receive a letter stating whether the Social Security was approved or not once the audit was done, and they said that could take up to 3 months. Now, the very next day, I received a large chunk of change in my checking account from Social Security. So does that mean I was approved, or did they screw up?
I love it. I really love the question. You did not play lotto, did you? Yeah, you were most probably approved, and then somebody must have picked it up for whatever number of reasons. We're seeing a lot of that. And as long as your medical records are there, as long as everything it's fine. What happens is once in a while, it's like a quality control. Did you get approved because you knew the person at Social Security? Was there a relationship? Is it just random? It was maybe a little too quick for somebody's comfort zone. But if you were paid and you haven't committed any fraud, you probably will get your decision after your payment. Congratulations.
And then my other question is about the neurofeedback.
Yes, please.
So I didn't understand pretty much anything you said when you were talking about it.
That doesn't surprise me. So
I didn't quite understand. So if you could please explain a little bit about that, and is it a benefit, and what is it, and why should we do it?
Sure. Just real briefly again, what neurofeedback is, it's a form of biofeedback. So what we do is we use your EEG. We're measuring the electrical activity of the brain. We place electrodes on the scalp based on symptom profiles. So for example, if we're helping with sleep, the electrodes will be placed different than if we're helping with focus and attention. We measure the electrical activity of the brain. We program into software targets that we want your electrical activity to achieve. We don't want your brain to produce any instabilities, and we want the brain to produce optimal performance, optimal functioning. Those are two parameters. When your brain achieves that, we feed that back to you. So what we're doing is we're feeding you back to you your own brain's electrical activity by watching a movie. The movie screen pulsates and mirror images brain functioning.